Hi everyone, my name is Elvis Abenga, here again to just discuss this act called the Protection Against Domestic Violence Act. I've had a lot of questions about restraining orders and how they apply in Kenya. This act, the Protection Against Domestic Violence Act, is the primary act of parliament that we use when we are applying for restraining orders. So this tutorial is going to be in two parts. The first part, we're going to discuss the provisions of this act and what it says, and then the second part of it, I'm going to show you how we draft pleadings for domestic violence and for restraining orders. These tutorials are geared not just to advocates, but also to those who may not afford legal services and they want to be able to represent themselves and get restraining orders for themselves. They should be able to apply this act. So moving on, I'm going to show you what the act says. First and foremost, in Kenya, this is the legislation that deals exclusively with matters relating to domestic violence. So that is why we call it the Protection Against Domestic Violence Act. It was an act that came in response to numerous cries from men and women alike who have suffered from domestic violence and who common law would not be able to assist. Before this act, if you needed help from the courts, you would just file an application like a normal court application seeking help, and it would be up to the discretion of the court to decide the kind of help you need. But once the Protection Against Domestic Violence Act came in from 2015, we now have a legislation that protects each and every one of us whenever we face a situation of domestic violence. So that's why we're saying that when you look at the act, it says it's an act of parliament to provide for protection, relief of victims of domestic violence, and to provide for the protection of a spouse and any children or dependent persons, and for matters connected. So it's just a matter of taking care of victims or survivors of domestic violence, providing for their protection. So if you're facing domestic violence and you need protection, the act provides for you. Yeah? So it raises a lot of issues, a range of issues that start from defining what abuse and the remedies, and we're going to look at what abuse really is. So under the act, maybe before I even get into this, I'd like to say, when you talk about domestic abuse, the most common thing that people think about is physical abuse, being beaten, where one spouse or one partner beats another spouse or another partner. But under the PADVA, as I will call it, PADVA is simply Protection Against Domestic Violence Act. Under Section 2, we have different types of abuse. We have sexual abuse, like what the Sexual Offences Act says, things like rape, unlawful penetration, things like sexual harassment, sexual assault. All that is defined as abuse under the PADVA as well. Now, I've heard people say whether there is anything such as marital rape. Rape under the Sexual Offences Act can be committed even in the context of a marriage where there is no consent to sexual penetration. So the PADVA picked up on that and built up on it to provide for sexual abuse as a kind of abuse, then provide for physical abuse, So, and this physical abuse is not just the physical violence that has been meted towards a person, but also any threat to any kind of physical violence that amounts to abuse, as I would call it, and as the law would call it. Then we have an interesting one called economic abuse. So, economic abuse is unreasonable deprivation of economic or financial resources to which an individual is entitled to or requires, and it includes household necessities, medical expenses, school fees, rent, mortgages, or other similar expenses. It also includes denial of an individual of their right to seek employment or to engage in income generating activity. Now you have guys, and this unfortunately happens a lot to women. You're a woman, you get married to a guy, and the guy says, you know what, you don't need to work, I'm the man of the house, let me work, I'll give you the money. I prohibit you from getting into any income generating activity. That is economic abuse, and it's illegal under the Protection Against Domestic Violence Act. In the same situation where someone denies you the necessities, doesn't help you, doesn't provide for the household, doesn't pay fees for your children, doesn't give you medical expenses, that is economic abuse under the PADVA. Then we have emotional, verbal, and psychological abuse. This emotional, verbal, and psychological abuse is a pattern of degrading or humiliating conduct towards an individual that includes insults, ridicule, or name calling, and threats to cause emotional pain. So, when someone insults you repeatedly, calls you all these bad names, that is abuse. You are being abused under the PADVA, and you need to take action. And then we have psychological abuse to a child, which is on its own category. So psychological abuse is where someone causes or allows the child to hear the physical, sexual, or psychological abuse of a person with whom the child has a domestic relationship. Or someone puts the child to be, or allows the child to be put at a risk of seeing or hearing the physical, sexual, or psychological abuse of a person with whom the child has a domestic relationship with. So in such a situation where you find violence, a man is beating his wife and the child is seeing that, or a wife is beating her husband and the child is seeing that, or the child is hearing the man or the wife insulting the other partner, that is deemed to be psychologically abusing that child, and it is illegal. But what exactly is violence? So under Section 3 of the PADVA, domestic violence means a threat. It means violence against the person or a threat of violence or imminent danger to that person by any other person with whom that person is or has been in a domestic relationship. And we are going to see what a domestic relationship is under the Domestic Violence Act. So where there is actual violence, and we've talked about this other stuff that we talked about: abuse, physical abuse, economic abuse, emotional and psychological abuse, or abuse to a child, where we have that kind of violence or a threat of violence that puts someone in imminent danger, that is domestic violence. But for it to be qualified, this person must be in a domestic relationship with the abuser. So let's see what a domestic relationship is. Section 4 defines what a domestic relationship is. So these people here are classified as being in a or having been in a domestic relationship. 1, people who are married or have been previously married. 2, people who are living in the same household. You're living with someone, you can domestically abuse them regardless of the fact that you're not legally married to them. So this covers what we now call come, we stay relationships. Then we have family members. We have people who are engaged to be married. You have your boyfriend, girlfriend, or a spouse or fiance, that kind of situation. People with a child or children together. So this includes baby mamas and all that, baby daddies. For as long as you have a child or children together, you're covered under this. People who have close personal relationship. This includes very close friendships. And now it continues to define more about what domestic violence is, and it includes child marriage, FGM, forced marriage, forced wife inheritance, interference from in-laws. Did you guys know that? So if you're married and your in-laws are always showing up in your house, trying to interfere with your marriage, trying to rule your household, trying to determine things, they are domestically violating you, and you can get an order kicking them out. Virginity testing, sexual violence within marriage. So indeed you can see sexual violence can happen within marriage. Widow cleansing as well. Damage to property where someone does that. Defilement. Then we have depriving the applicant or hindering the applicant from access to or a reasonable share of the facilities associated with the residence. So I'll give you an example of this. For instance, you have one person denying the other and telling the other person, you know what, you cannot go to the kitchen, or you cannot go to the washroom, you cannot go to the sitting room, you cannot share the facilities associated with the residence. That's violence. Then we have economic abuse. We already talked about that. Emotional and psychological abuse. Forcible entry into the applicant's residence. You know, someone, you have your ex-girlfriend or ex-fiance or ex-boyfriend and vice versa, and your ex forces themselves into your residence. That is violence. Harassment, incest, intimidation. Man, this is a lot of list, but this pretty much covers a big deal of what domestic violence really is, especially in Kenya. Then physical abuse, sexual abuse, stalking. You know, you have those guys who just stalk you, you know, sending you messages, yo, I've seen you, you've just left your house, I've seen you talking to so and so. When you're being stalked, you are being violated. Then verbal abuse happens, and then we have a very broad categorization here saying any other conduct against a person where such conduct harms or may cause the imminent danger to that person. As you see, all this is under Section 3 and Section 4 of the Domestic Violence Act. Okay, now let's talk about the court. So you've been violated, you think you need a restraining orders. You know, now in legal speak, the Act doesn't use the word restraining order. It uses the word protection order. But normally in people just know that they're restraining orders. But for purposes of this presentation, we are calling them protection orders because that's what the court and the Act say. So if you have been violated and you need a protection order, what do? You go to the resident magistrate, the magistrate's court. That is under Section 24. You don't run to the High Court. It's an application that is filed under the PADVA is always filed at the magistrate's court. Now, once you file, what does a protection order do? So let's see it under section 19. It says a protection order may direct that a respondent, and here the respondent is the person you've sued or the person who's abusing you, shall not do any one or more of the following. So physically or sexually abuse or threaten to abuse you as the protected person, damage or threaten to damage any of your property, engage or threaten to engage in intimidation or harassment, which amounts to psychological abuse of the protected person, among many other things. So the court can issue this kind of order, which almost operates like a restraining order, but it's called a protection order, that stops the person from engaging in this kind of behavior. Assault, threats, intimidation, stalking, harassment, damage to property. They can be stopped from doing this by the court by virtue of section 19 of the Act. Okay, so how do we exactly apply for this protection order? Provision is provided for under section 24 of the Act. So, it's lodged and where directed by the court says, it's supported by an affidavit of a person who can depend to the matters which are relevant to the application, and it requires either a social worker, probation officer, medical practitioner, children officer, or other appropriate person or authority to investigate the acts or omissions of the domestic violence and forward the finding directly to court. So when you're making an application, and this will become clearer when we are drafting the actual documents in the second part of this tutorial, you must have an affidavit. Either the person, you as a person who's seeking protection, if you're drafting for yourself, you must sign the affidavit saying the circumstances under which you're asking. Why are you asking for protection from the court? And in that application, you must ask that either the police investigates or a social worker or a probation officer, depending on the circumstances of the case. The court can actually require you to require these people to investigate these acts to determine whether or not domestic violence is being or has happened for purposes of protection. So who can apply for protection orders under section 8? We have a person who is in a domestic relationship, and we already defined what a domestic relationship is, a representative of a child such as a parent, and we have an applicant's representative, very interesting, under section 10 of the Act. Sometimes you have someone who is being abused so badly that they are not in a position to represent themselves. So you as a friend, as a colleague, as a relative, as a neighbor who is observing this person continuously being abused, you are able to make an application as an applicant's representative for purposes of protection orders for the person you're applying for. So then we have under section 10 some people who do not have capacity. So these are like persons who are not children. If the person is not a child, but for some reason, either because of mental issues or the nature of the violence that has been meted on them, they are not able and they don't have capacity to be able to help themselves or to understand the nature of how the application is done in domestic violence. You can be able to make application for them. And under section 11, we have people who need protection orders but are incapable of applying for them. So it says any person may apply to the court to be appointed as a representative of the person of this kind of person for purposes of applying for a protection order. So I'm going to reiterate this. You know someone who's undergoing domestic violence and needs restraining orders and protection orders, but this person is not able to apply for themselves. You can apply for them. You can move the court for the court to appoint you as a representative for them for purposes of getting the necessary protection orders. So what does the court consider? What are the grounds for appointing of a representative? So one, you as a representative, you must have ascertained the wishes of the victim. You don't just walk and without the victim consenting to that. So the victim must consent to being represented. The appointment must be in the best interest of the victim, and you as a representative must be able to have accepted your appointment in writing. So you can actually get the person who's being abused to just write a note appointing you and consenting to you being appointed, and you write back accepting that appointment. So you file these documents as part of your documents in applying for the court to allow you to act as a representative of the victim. And also you must be able to demonstrate that there is no conflict of interest between you as the victim and the representative. Between the victim and you as the representative. So sometimes, I'm sure by now you're asking what happens when the victim does not consent but still needs protection orders. It is possible to do away with the consent of the victim, but only with the court's permission. That is usually a very huge toll to get, because you tell the court this person is clearly being abused. They are not in their frame of mind. They have not consented, but we still believe that they need some kind of restraining order or protection order, and the court can dispense and do away with the consent. That is what we say when you're saying with the leave of the court. So in such a case, what happens? When an application for protection order has been made by a person who is not the victim, so the court does not commence the hearing of the application until it does not commence or continue with the hearing of the application if the victim comes and objects to the application. So the court will first hear that objection and then determine whether or not to proceed and hear the application or not. So that's the process. Then sometimes under section 24(3) of the Act, it says that where an applicant is not represented by an advocate, the court will then proceed to do a few things. One, advise the applicant. Now in this case, if you're representing yourself, he'll be advising you of the reliefs available under the Act, effect of any order which may be granted. So if there's an order, the court will tell you this is what the order says and what it means, as well as your right to lodge a criminal complaint against the perpetrator, as well, and lastly your right to claim compensation for any loss suffered or injury caused by virtue of domestic violence. Now let's talk about interim protection orders under section 12. So these are also known in layman terms as interim restraining orders. So an interim protection order is usually given in the following circumstances: where there is a risk of harm and it's very real, like the court just has to act even before hearing the entire matter. There's a serious risk of harm, there's a serious risk of undue hardship to the applicant or who's applying, or to the child of the applicant's family. And once you make an application under Section 12 and the court is satisfied prima facie, meaning at first sight, that the respondent has committed or is threatening to commit an act of domestic violence, in addition to issuing the interim protection order that we just saw in Section 12 above, it can issue a show cause, which is called a notice to show cause, that directs the respondent to show cause why they should not be issued with a protection order. So this is regardless of whether the court gave an interim protection order, but sometimes in this case you'd see the court might see that there was violence or threat of violence, but that the circumstances don't justify issuing an interim protection order, and so it instead issues a notice to show cause. So some such circumstances is, for instance, if the two parties are not living in the same house. If the applicant and respondent are in different places and there's enough security, nonetheless, a show cause will most likely be issued to demonstrate, for the respondent to demonstrate why a protection order should not be issued. And even in terms of where there was an interim protection order, there are times the court will still issue a notice to show cause after issuing an interim protection order. So the notice to show cause will be for the respondent to show cause why the protection order should not be made permanent. So now we usually have in law we know a rule called sub judice, which means that you cannot have two matters relating to the same parties and same course of action in two different courts at the same time. But the Protection Against Domestic Violence Act under Section 15 says a court shall not decline to make a protection order merely because of the existence of other proceedings, excluding but not limited to proceedings relating to custody or access of a minor. So I've had cases in court where there is a child custody case going on in the children's court, but then there is also an application under the Protection Against Domestic Violence Act, and someone would come and raise what is called a preliminary objection and say, no, we cannot hear the Protection Against Domestic Violence Act because we have a child custody case going on at the children's court. Under Section 15 of the Act, regardless of those other proceedings happening, the PADVA, the Domestic Violence Court, has jurisdiction to still proceed nonetheless. Also, the fact that someone has applied for protection orders, it does not stop or bar criminal proceedings coming up. So it is possible for criminal proceedings to still proceed under the PADVA regardless of the fact that there are protection orders. So what types of protection orders can be given? We have some protection orders called the no contact order, which is the most common type of restraining order, protection order given. The no contact order simply says, do not let the respondent not contact the applicant. This person who's issuing threats left, right, and center, let there be no contact. Also, we have a very powerful kind of order called the exclusive occupation order, which we are going to talk about now under Section 19. Now, guys, this is serious stuff. It says that Section 19 that the court may, in an order under this section, subject to subsection 6, grant to any protected person the right of exclusive occupation of a shared residence or a specified part by excluding the respondent from the shared residence or the specified part, regardless of whether the shared residence is solely owned or jointly owned or leased by the respondent. Let me break this down. What we are saying here, imagine you have a situation where you have a man and a wife and they're jointly owning a house. The court can still kick either of them out. The court can tell the man, you are abusing your wife, so get out of the house for some period of time. Or tell the wife, you're beating up your husband, get out of the house. Even when you're jointly renting the place, the same can happen. These are called exclusive occupation orders. It does not affect the rights under Section 19(6). The fact that you've been kicked out because of a restraining order does not affect the fact that you might still own that premise or you have any other right. And most times exclusive occupation orders are usually given for a limited period of time to allow the protected person time to arrange their affairs in a way that they can be able to be protected. So where the protection orders have been issued and the respondent or someone is not happy with that, under Section 30 of the PADVA, you have a right to appeal to the High Court. Lastly, where you have a right to ask for compensation under Section 32. So where you're a victim of domestic violence and you've suffered personal injury, damage to property, financial loss, you can claim compensation, and the court will then be able to gauge and award the level of compensation that will give you as a protected person or a victim of protection. So the considerations that are given when calculating compensation: 1, pain and suffering; cost of medical treatment; loss of earning; amount of value or of the property taken or destroyed or damaged; and any reasonable expenses incurred by or on behalf of the victim for purposes of separation. So all the loss that you've suffered, you are liable to be able to, you are entitled to compensation, not liable. Sorry for my choice of language. So in conclusion, this is a young piece of legislation, came into existence in 2015. There are still a few gaps that need to be filled. There's still a lot of training that needs to be done. But nonetheless, we can still be able to apply for the necessary restraining orders, protection orders, not just for ourselves where we feel there's need to get restraining orders or protection orders, but also for the purposes of other people who may need help and are not in a position to help themselves. In the second tutorial video, I will actually show you the process of drafting the necessary court documents under the Protection Against Domestic Violence Act, so you can be able to put theory into practice and learn how to do this, not just for yourself but for any other person. Thank you for watching and listening to this tutorial. I hope you have found it very useful, and God bless you as we try to make Kenya a domestic violence free country.